Mr. Tucker is here today after failing to appear before this court on November 15th, 2023. For the record, that was a bench warrant hearing. Mr. Tucker had previously posted a $718 bond on October 27th of 2023. That was prior to him having a bond review hearing. So he posted the full bond and then failed to appear for the hearing. Bond is currently set at $699. This is the 11th bench warrant. He reports no employment. Last payment made on this account was in September of 2021. However, the bond has not yet been applied to the case. Front of the court requests that a reasonable bond be set in this matter and it be scheduled for hearing on November 29th, 2023 at 8:45 a.m. before this court.
Mr. Tucker, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on November 29, 2023 at 8:45 a.m. Are you able to post a bond, sir?
Yes. What is the bond?
Okay. Well, I see that
I don't understand how I didn't get nothing in the mail about me having to come to court on what day he said it was, the 15th.
Yes.
He said I've been checking my mail like every day and I never seen nothing from child support about having to come to court. I knew something was coming soon because I knew I just bonded out, but I still didn't get nothing, so I didn't know when it was coming. But I knew because they always have a hearing after you post bond.
yes, we do. Just like now, I'm telling you, the next hearing is going to be November 29th.
I'm glad you told me that. They never told me what it was last time, but I'll remember this now.
At 8:45. Okay, what I'm going to do is I am going to reduce your bond slightly in hopes that you could be released. But I do note you have 11 bench warrants previously. I'm going to set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay, thank you, sir. You're excused. Have a good day.
In each of these matters, Mr. Martin is here today after failing to appear before referee Croteau on March 3rd, 2022. Bond in each case is currently set at $500. This is the 5th bench warrant in the first case, and I do not have the number of bench warrants in the second case. He reports that he is employed at Systex. Last payment made on these accounts was in March of 2023. Front of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on November 29th, 2023 at 8:00 a.m. before this court.
Thank you. Mr. Martin, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on November 29, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, sir. I just started working at Systech Tuesday. I had my orientation Monday. I started work Tuesday. I don't want to lose my job because I know I didn't go to court. I've been homeless for a year. I stay at the Battery shelter right next door. I don't get in trouble, Your Honor. I don't do anything wrong. I try to be the best person I can. I have 3 kids. Christmas coming up. My life been really messed up so far. I've been sleeping outside before I went to the shelter.
Okay.
I just started work Tuesday.
Okay. If you're released today, will you still have your job?
Yes. The person, my team leader, he lived at the Battery shelter with me. When I got arrested Saturday, he was with me. I told him, I said, I knew I was going to jail. I knew I had warrants. I'm not running from nobody. I knew I had warrants. I told him, I said, hey, can you please save my job for me? He said I could do my best I can. So when I called my mom, I told my mom to call him. I'm like, hey, can you please tell me if I can keep my job? Because even though they only pay me $15, it's a job. and
Yep.
I just want to keep it and give my kids Christmas and pay my fines off. And
Okay.
and the Salvation Army, Sally, they said they'd help me out with housing vouchers because I don't want to keep staying at the Baptist shelter.
Okay. Well, Mr. Martin, what I'm going to do is I am going to take a chance on you. I'm going to set your bond in the amount of 0. You understand that? So you don't have to post a bond. You'll be able to get out.
Yes, sir.
But you have to appear back on the November 29th date. And
Yes.
you can appear. You'll need to call into your worker in the morning, first thing. You might be able to work out something with them. If you do, then you wouldn't have to come back on Zoom. But if you don't, you'd have to come back at about 10 o'clock on Zoom. But I'm giving you this last chance because I do want you to keep your job, and I think you're sincere about doing that. I will tell you, if you don't show up on that November 29th date, you're not going to get out without posting a bond in the future. You understand?
I understand, sir.
Okay. Well, you're excused. Have a good day. And it's going to take a little bit of time, maybe an hour or so, for them to do the paperwork to be able to get you out.
Mr. Ullman is here today after failing to appear before referee Bradfield on August 4th, 2023. Bond is currently set at $1,357. This is the first bench warrant. He does report employment, but I was unable to read what it said. The last payment made on this account was in July of 2023. Front of the court recommends that a reasonable bond be set in this matter and to be scheduled for hearing on November 29th, 2023 at 8:45 a.m. before this court.
Thank you. Mr. Allman, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on November 29, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I believe so. I just wish I'd known I had this court date. I would have been able to avoid all of this.
Yeah. Well, what I'm going to do is I am going to reduce your bond in hopes that you could be released pending that hearing. I'm going to set your bond in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir. Maybe I get. Go ahead, sir.
Can you verify your employer for me?
It's official driving school instructor. It's through the
Official.
Michigan. Yeah, it's at the mall. That driving school at the mall.
Okay, say that one more time. Official what?
Official driving school instructor.
Driving school.
Yes, sir.
And the name of the employer is what?
Official driving school instructor.
Okay, that's what it is.
I did my interview. It's supposed to be in Grand Rapids where I'm doing my classes for the certification.
Okay. Okay. You have started to ask a question, sir.
And I kind of forgot what it was.
Okay.
I apologize, Your Honor.
Well, that's fine. We'll be able to discuss all of that on the November 29th date. So, okay, that's all we have today, sir. You're excused.
Ms. Snyder is here today after
Thank you,
failing
sir.
to appear before this court on September 27th, 2023. Bond is currently set at $500. This is the second bench warrant. She reports no employment. Last payment made on this account was in August of 2023. And for the record, that was a $642 bond forfeiture. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on November 29th, 2023 at 8:00 a.m. before this court.
Ms. Snyder, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on November 29, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond in this matter, ma'am?
to my knowledge, it's not 500, it's $1,080 or something like that, which I can't post. And am I here because of a missed court or something? Because they told me when I posted that bond that since the payment was going to child support, that I would not have to show up for another court date.
Well,
Or,
yeah, you missed the court hearing.
Yeah,
Back-
she told me I didn't have to come to that because child support will be receiving that payment in September. So
Well, I don't know who would have told you that, but that's not the process. So unfortunately, you've got incorrect information.
It was the court that told me.
Well,
So what is the bond?
what I'm going to do is I am going to reduce your bond hopes that you could be released. I'm going to set your bond in the amount of $400. If you're able to post that, you'd be able to be released. Do you have any questions?
So it's just $400.
$400, correct, ma'am.
No,
Okay.
I haven't.
Okay, thank you. That's all we need to do today. You're excused. Have a good day.
In each of these matters, Ms. Crouch is here today after failing to appear before referee Nets on December 10th, 2021. In the first case, bond is currently set at $1,328. This is the third bench warrant. In the second case, bond is currently $517. This is the eighth bench warrant. And in the third case, bond is currently $1,644. This is the seventh bench warrant. She reports no employment. Last payment made on these accounts was in March of 2023. Front of the court recommends that reasonable bonds be set in each of these matters and they be scheduled for hearing on November 29th, 2023 at 8:45 a.m. before this court.
Ms. Crouch, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on November 29, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
Yeah, I got like 300.
Okay, well, unfortunately, with the amount that you owe in this matter, that's not going to do it. What I'm going to do is on your 2008 case, I'm going to set your bond in the amount of $100, and in the two other cases, I'm going to set it in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
No,
Okay, thank you.
thank you.
Free to go. Have a good
Ms.
day.
Dowdy and I were able to talk before today's meeting, and right now I believe we are both in consent to do a DNA test. So this motion was to set aside the default, and I think setting aside allowing the DNA test to affirm that he is the biological father, and then scheduling another time to go before you once we have those results.
Okay. Well, obviously, if he's determined to be the father, there's no need to maybe set aside the default. Maybe we should just do an order to order some DNA testing, and then you can renew the motion at that time.
Okay.
And I would say at that time too, make sure, because I know looking at the motion, the affidavit, your client didn't sign that, so I'd want that signed by him.
Okay, I did. There was COVID issues at the jail, and so I signed on his behalf. And I think under court role as an attorney, I can sign on his behalf, but I do have a new signed one for him.
Okay, that'd be fine. So why don't you do, Ms. Grantham, why don't you just do an order for DNA testing, and then we'll revisit it depending on what happens at that time.
Sorry.
And what we can do is we can set, when we do we have those hearings on Wednesday afternoon at 1:30. Once you get the DNA test results, you can contact my office and see when we can schedule that.
Okay. Also, one other matter, because I believe that the jurisdiction might or the authority might be with you, and that is if we could have a PR bond and allowing Mr. Ware to not only go and do the DNA test, but also continue to participate via Zoom, so he can go to work and have some funds available to not only help pay for the DNA, but in the event that he is the father, start paying for the child support.
Okay. Why is he in jail?
For this matter specifically, he did not have the order, so he was not paying, his money was being garnished from his checks, and he was extradited from Kansas to here. And now that he's fully aware of this, and he has no criminal record, and being completely fully aware, and his attention is definitely been had, that he be allowed to leave jail, go back to work, and participate via Zoom.
Okay. Has he previously had any bench warrants for failure to show in the past?
No, Your Honor.
Okay. Well, I'll accept your representations, Ms. Grantham. I'll allow him to set a bond in the amount of 0, which will allow him to get out. Ms. Grantham, you're going to have to contact the front of the court and coordinate that, because they can get the order to me. But being that this wasn't on their schedule, they're not going to be set up for it, so you'll have to make arrangements with them to get that paperwork to me in the order, which would allow him to get out. So I'll leave that up to you, and contact them and let them know.
So this is a rarity for me. So when I contacted the friend of the court, is there somebody specific, or should I call your clerk? She could better direct me. Yeah,
check with her and see. She won't, obviously, she's doing the motions, so she won't be available till probably about 11. But you can, Ms. Woodard, would Kristen Schwab be the one that she'd have to speak to down there?
I would think she could start with Kristen, Jeff Chapman.
Yeah.
Okay.
Probably Kristen Schwab.
Okay.
And check with her first, and then she'll be able to direct you.
All right. Perfect. Thank you very much.
Okay,
Tabaka.
I thought that they had agreed to have a hearing on this.
This is a new motion.
Okay.
Oh, I mean, they may. We have scheduled an evidentiary hearing. So let's check.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. Elaine on behalf of the defendant. This matter is before the court on the plaintiff's motion for attorney fees. I do note that we do have, I have reviewed the motion as well as the answer in this matter. Based upon that answer, it does appear that we would need an evidentiary hearing in this matter. And I do note that we do have an evidentiary hearing scheduled as it relates to another matter. So, Mr. Schaefer, do you have any opposition to just putting this matter over to that and addressing that at the evidentiary hearing as well?
I think that probably makes sense. I anticipated the court would set up an evidentiary hearing.
Okay. Ms. Elaine, does that sound reasonable to do to you?
Well, Your Honor, I think there's grounds to just dismiss the motion without an evidentiary hearing based on the deficiency of even alleged facts in the motion and the fact that Ms. Tabaka has demonstrably misled the court with regard to certain critical facts. So I think an evidentiary hearing would be inefficient for this court, but also cause an expenditure of attorney fees that Alexis is complaining about that is again going to be another self-inflicted wound and cause Dr. Tabaka attorney fees that he should not otherwise have to pay.
Well, and looking at this case, it does look like it's a rift with self-inflicted wounds. So I think it's a death by 1,000 cuts. So what we're going to do is, I do believe it's premature to address the attorney fees till I've heard the case in this matter. So the court's going to simply reserve on that, and we'll wrap it into the evidentiary hearing that we already have, and we can address the matter there. Just, Ms. Elaine, I do note, based upon your answer, there's some factual issues that need to be addressed, which I'll want to address before I would make a determination in that matter. So we will reserve it until that particular hearing.
Your Honor, excuse me, there are a number of hearings that are pending. Could you give me the date of the hearing that Your Honor is referring to?
I'll have Ms. Woodard to look it up.
Yep, I will check. Looks like January 18th at 1:30.
Okay, very good. Thank you.
Okay, we will see you all back then.
Your Honor, may I ask a procedural question, please?
Sure.
On that date, that's set for an evidentiary hearing on a show cause motion that this court scheduled. Would we go first on the show cause, and then just so that I know how to prepare for that
Sure,
hearing?
we'll let you go first.
Okay.
The motion was first, and then we'll proceed.
All right,
Okay.
thank you, Your Honor.
Thank you. Court will end this matter at 9:06 a.m.
Good morning
If
to
you
all
have a
of
good
you.
day.
Thank you.
Good morning, Your Honor.
Court will note the appearance of Attorney Jordan on behalf of the defendant. This matter is before the court on the defendant's motion for, well, to compel discovery and for an expedited hearing. Ms. Jordan, I note that you have a hearing on December 8, 2023. What's the subject of that hearing?
It is a continued evidentiary hearing on defendant's motion to modify custody and parenting time.
Okay.
First hearing was held on September 27th.
Okay. Go ahead with your motion.
Thank you, Your Honor. So currently before the court, we have a pending motion to modify custody and parenting time. On September 29th, defendant's counsel by ordinary USPS mailed to the plaintiff defendant's first request for production of documents. Plaintiff was asked to provide copies of his 2021 and 2022 W-2s, 1099s, and or K-1s from all sources of income and employment, produce copies of his 2021 and 2022 personal and state and federal tax incomes and all supporting documents, copies of his last 6 pay stubs or proof of income from all sources, including but not limited to any inheritance, retirement distributions, monetary gifts, Social Security and or disability payments, unemployment income, etc., and to provide a list of names and facilities and a fully executed release for all medical, therapeutic, rehabilitative, etc. facilities that he has been treated at since February 11th of 2021 to the present. And a blank release was attached for the plaintiff to complete and return.
Okay.
Copy of the same should have been attached to our motion as A. More than 28 days have passed since service of this document and no response has been received to the same. This
Let me ask Mr. Jones. Mr. Jones, why did you not respond to the discovery request and why have you not supplied that information?
So I have had issues with mailing in this case since the very beginning. The original filing to request an evidentiary hearing for this case to change the parenting time, they waited until I was out of state and knew I wouldn't receive it so that I couldn't appear.
Okay, let me ask you this. Again, going back to the original question, why have you not supplied the information as to your income and the medical releases?
I was trying to get there. So,
well, get there. Don't just try to.
Oh my God. I did not receive it. I received the second one where it says I failed to comply. And as soon as I received that, I tried to phone Mrs. Jordan, and then I got an email, and I responded via an email and said I will work on them. But she had already filed this, and I am waiting for 2 W-2s from previous employers. The taxes I do not have. I'm working with a company. I am trying to file back taxes. I did not file in 21, 22.
Okay. Well, you can always, when you do that, sir, you can always when they have that and ask for that information. You can always say, I have not filed for those years, so I don't have those available. That's easy enough. You just have to communicate. What the court's going to do is the court is going to order that Mr. Jones comply with the discovery request and provide all of the discovery requested information that he has available to him or an explanation as to why he can't, and that he do that no later than November 30, 2023. So,
Your Honor, may I?
Go ahead.
I object to the request for my medical and therapeutic records. That is protected information that they have no business reading.
Well, sir, part of the case with regard to custody does go, one of the factors under the Child Custody Act is the mental and physical health of the parties. So you can keep that information private, but I will tell you, if you do, the court will then infer that factor would favor the other side. So you're going to go into this hearing with the idea and understanding that you'll be missing or losing that particular factor under the Child Custody Act. You understand that?
I don't understand, but I understand. I don't understand how it's relevant. But in that case,
Well, it's
Your Honor, I
relevant. It's
request-
relevant because the legislature says it's relevant.
Well,
and the
no, I
court has to
understand. So I'm
follow
saying
that.
I don't agree, but I understand.
Okay.
In that case, can I request through the court that I receive the medical and therapeutic records of her husband, as he also suffers from PTSD and lives in the house?
Well,
And has a history of violence?
he's not a party to this. You can make a discovery request, and then we'll address that at that particular time. But it's premature for the court to again step in and say, I don't know if they're going to comply or what. So I don't know what the issue is, but you have a right to make a discovery request, and then we'll address it at that time. Okay.
Okay.
So the court will order the disclosure of that, as well as, again, the signing of the medical information relief forms, unless Mr. Jones does object, and that he has a right to object. If he does, then the court will, as I stated, will take that into consideration and will hold that factor against him and will infer that, in fact, it would be, I guess, perceived, if you would, or that it would be held against him for failing to disclose that and keep it private, but he can do that. So, sir, do that. You have until November 30th, 2023 to do that. So you better, you've got a week and a half, get that done. And the court will reserve on the attorney fees. And Ms. Jordan, you can prepare that order, submit under 7-day notice of entry.
Will do, Your Honor. And just for the record, the issue of the medical has come up in the first evidentiary hearing that we had as the plaintiff opened the door. And the referee had already made a determination that that was relevant and the door had been opened. But
Okay. Well, you have the court's ruling in this particular matter, and you can address that at that hearing on the 8th.
absolutely. Thank you, Your Honor.
Okay, thank you.
At 9:34
Court won this
a.m.
matter at 9:15. Good morning to
You're
all of you. Court will note the appearance of Ms. McNiff on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to modify parenting time. Ms. McNiff.
Your Honor, we've given significant reasons and issues that have been occurring with the parenting time between the parties. And in the interest of providing the child with some consistency and stability and safety during parenting time, we are requesting that parenting time occur at Family and Children's Services on a weekly basis, that Mr. Alvear be prohibited from using alcohol or marijuana or any illegal substances prior to or during that parenting time, and that he be required to provide Ms. Blanchard with a working telephone number and his address. There have been so many changes in his residence that she simply doesn't even know where he would take the child if he were to have parenting time. It's getting cold. Having parenting time outside is not going to be as feasible as it has been in the past. And as the court can note from our pleading, there's been problems even with that outdoor and public parenting time. And we're also asking that all communication between the parties be accomplished through our family wizard, which actually might take care of the telephone issue as well, if she has access to that app and Mr. Alvear uses that app, then perhaps if he changes phones, he changes phone numbers, which happens on a regular basis, they would still have the ability to communicate with regard to their child.
Okay, thank you. Mr. Aviar, what's your response?
Honestly, Your Honor, I'll be honest with you. I don't care what it takes to get to see my son. And the paperwork I have, it says something about me getting to see him once a week. I don't agree with that. I would like to get to see him more than that. I don't care where I have to go to see him. I don't care if it's supervised, whatever. I do have a good address now that I would be able to keep the child at if I were allowed to. I have a good working number. I don't really care what the stipulations are. I would just like to be able to see my son. I have tried multiple times, and yes, she has given me a couple of chances to see him, but there's been several times that I've tried to see him and all I get is, I'll let you know, or we're busy, or we have plans.
Well, if that's the case, sir, you always have a right to file a motion to modify parenting time as well, setting forth specific facts as to why the court should do that. So that's up to you. At this point, it's just under their motion. Court does note that, again, the order does provide for the parenting time to occur at all times and places which the parties can agree. So obviously it does give the plaintiff complete control at this time. What the court will order is that the defendant would not consume alcohol, marijuana, or illegal drugs during parenting time, that he would provide the defendant with a working phone number as well as an address where the child will be at for purposes of parenting time, and that the parties would communicate through our family wizard in this matter, and each party would pay 1/2 the cost of that app and the subscription service. Court will let the parties know that, again, any communication through our family wizard is in fact retained. The court does have access to that. So if the parties are going off during the communication, or if things are said, or if somebody's being mistreated, the court will have, again, access to that communication. So court will simply advise both parties that, govern yourself accordingly, because the court will have that. That will be the order of the court at this point. Ms. McNiff, you can prepare an order to that extent. And sir, if there's other things as it relates to parenting time, you have a right to file that motion, and you can file it at any time. Okay? That will conclude this matter at 9:38. Good morning to all of you. You're free to go. Have a good day. Court will note the appearance of Ms. Huffman on behalf of the plaintiff, Ms. Jensen Miller on behalf of the defendant. This matter is before the court on the plaintiff's motion for modification of custody parenting time support and to show cause. Ms. Huffman.
Oh, thank you, Your Honor. Just a quick update. Since the last hearing, the CPS worker in this matter has yet again sent a referral to close the investigation. There has never been any substantiation of any accusations at all in this case. And now we have a child telling people that she can't see her daddy anymore because her mommy keeps saying he molested her. And this just continues to get worse and worse. And the longer we allow it to go on, the worse it's going to get for this child. She's now having to see a counselor, and who wouldn't in this situation? I know the court read my motion in its entirety, because as I started to state things in the last hearing, the court already stated I read that. So I'm not going to get into any of that and repeat it.
Okay.
So it was, but my motion was set immediately on the first available Monday, just in case the court denied that ex parte motion. And obviously the court did deny that motion. So I had it set immediately so that we could get some immediate relief. And then we had a 2-week delay, and now we're here for on delay. So I'm just asking the court for some type of relief so that my client can get back to parenting time, get this child back on track. We've got to get things going again, parenting time going again. My client hasn't seen the child since he went to Indiana and took the child on the 16th of last month. And mom then came to the house, and all of the police calls were made and the troopers had to come. Okay. And as I stated, the child is now having to see a therapist because the mother's forcing things into her head. And mom has also circumvented this court's custody orders by filing for a PPO in Indiana. I'm asking this court for some type of relief at this time. Thank you.
Well, you understand, Ms. Huffman, court cannot change custody without an evidentiary hearing.
I do understand that.
Okay. Ms. Jansen Miller, what's your response?
Thank you, Judge. I'm not sure if you had received my written response or not. We had sent it up via email on Friday, along with the affidavit from another individual that was present at the meeting that was called by the plaintiff's family regarding these allegations and the statements by the minor child. Judge, it is true, the child is in counseling, and that counseling is a result of the issues that have been brought in. Dad showing up at the school, the underlying CPS investigation. I do disagree with what Ms. Huffman is indicating. My client just indicated that Chelsea Petrakis, the CPS worker, just called her and said that they had followed up with a couple of more things. They were going to reach out to the therapist, who has now said that she wants to see the child weekly to try to get to the bottom of some of this stuff. And that then the referral or the CPS investigation was going to go to CPS supervisor Tracy Sweet, who I mentioned in my answer, had indicated that Chelsea had not followed through with as much of the stuff follow-up investigation as she should have, which is partially why we're at this case right now. Judge, these are not allegations that a child just off the cuff states. And again, I want to bring the attention that these were allegations that were said to the plaintiff's family, and it was the plaintiff's family who then notified my client. And that was a month after there were a couple of other smaller things that were said, but now looking back are more alarming, regarding issues that the little girl had told mom. Mom talked with dad about it. Well, let's just see how it goes. She's a little girl. Do
you have any idea when, from what Ms. Huffman said, that they were closing their investigation, do you have any idea as to when they're going to conclude that investigation?
So my understanding is she was reaching out to Erica, the therapist, today, and they still have not talked with Aaron Freilich, who was the other person that was at this meeting. It's my understanding that the supervisor was going to try to make her, or was going to make her talk with her. Once the supervisor has it, they have 14 days to either approve it or deny it and send it back for modifications or for additional investigation.
Okay.
So I don't have an answer today.
Okay.
If I could, Your Honor, last Thursday, I received a screenshot that says directly from Ms. Petrakis, it will be submitted for closure today. That was last Thursday. My boss will then have 14 days to review it before it can officially be closed. I am still waiting to hear back from the counseling place and want to do another follow-up with you afterwards, but she was submitting it that day, last Thursday.
Okay. Well, let's do this. The court does note that at least with the motion in this matter does provide sufficient probable cause or proper cause and change in circumstances to meet the advarca threshold for an evidentiary hearing. So the court will set it for an evidentiary hearing. What the court will do is I had something open up. The court will set this matter for hearing on December 19, 2023 at 8:30 a.m. as well as December 21st, 2023 at 8:30 a.m. in case we need both days. And what happens is keep us apprised if there's some issues with, again, CPS, because obviously the court would like that concluded. Then either of the attorneys can schedule a status conference with the court and we'll address things at that point if we need to. Okay?
Okay, thank you.
That will take care of everything, at least today. We'll see you back on the December 19th date if we don't hear anything before that. Okay? Thank you.
Judge?
Yeah.
We have since scheduled stuff for both of those days.
Oh, okay.
Let me look and see if I have something else.
Yeah, what we'll do is we'll call both your offices and see when you're available. I didn't know that we had filled those days in, so. Okay, we will contact you and see when you're available and when we can get you in.
Okay, thank you.
Thank
Thank you,
you.
Your Honor.
Different times, but
All right.
as I stated in this matter, that the plaintiff had filed a motion to set aside referee recommendation, claiming that the defendant was making more than that she had told the court. Sir, at the hearing on October 20, 2023, you could have presented any evidence you had concerning her income. Why didn't you do that?
Well, I actually sent out I sent out a subpoena for it, but I might have sent it out too late. I have a date my date of delivery was on when I got this back was on the 18th. I think that was what, 2 or 4 days before the actual hearing. So I sent out for the evidence, but I got it sent out a little too late, I believe. Not enough time to get it back.
Well, a couple things you could have done at the hearing. You could have asked the referee for an adjournment to be able to get that information. I mean, rather than at this point, you don't, my understanding, you don't have any information now at this point that would contradict her testimony. Is that correct?
Correct, because they still haven't sent it to me yet. I sent out the like I said, I sent out the subpoena for it, but I never got the information.
Okay. Well, what the court's going to do is the court can't just speculate as to what somebody's testimony may have been. What I'm going to do, no,
Can I say
can't.
something?
You don't need to, ma'am. What I'm going to do is I'm going to deny your motion, sir. If in fact you get information that in fact her testimony was incorrect, you always have a right to file a motion claiming that there was a fraud committed on the court, and the court could take that up. Likewise, you also mentioned that you are now paying for medical insurance that you hadn't before. If that's correct, send the information to Mr. Todd, and maybe at that point he would agree to modify that, taking into account or giving you a credit for that medical premium. But at this point, you don't have anything which would cause the court to, again, modify and change the referee's order. So I'm going to deny it at this particular time. But that would be the way you want to proceed if you get other information, sir.
Okay, so I have another question. As far as he backdated it to July.
He would date it back to the date that the notice of, again, the modification would have occurred. That's correct.
Yeah, so that put me over $1,600 in arrears already.
I understand, but what happens is during that interim period of time, you weren't paying the correct amount. So that's always a risk because we don't know if it's going to go up, if it's going to go down, et cetera. But again, the referee did exactly what he was supposed to do, is he would have modified it effective the date of the motion to modify. So he did everything correct. So again, the court's going to deny the motion, and that will conclude this matter at 10:36 a.m. You're free to go. Have a good day.
Your Honor, did you want me to prepare an order, or was the court going
No, the court will have an order that we'll send out.
2023 at 10:37 a.m.
Court will note the appearance of Mr. Todd on behalf of plaintiff, Ms. Podolsky on behalf of defendant. This matter is before the court on the plaintiff's motion with regard to communication topics. Mr. Todd.
Thank you, Your Honor. Your Honor, the parties already have an order indicating that they'll only communicate through our family wizard, and that has been occurring, but the communication is well outside of the child. Defendants continuing to harass plaintiff to try to reconcile, requesting information about what she's wearing, where she's going, who she's with, and then sending extremely long messages about scripture. She has requested that he stop doing this, but he has failed to stop doing that. In fact, honestly, even today, there was a text message as an offer of proof indicating that the child said, "Mommy and Daddy are married, and I want Mommy to come home and be together." And there was a long message of scripture. And then there was a statement, we pray for you and the day, we love you, hope you're having an amazing day. I believe the answer indicates that Mr. Aldridge's statement is that he is only communicating about the child. And I guess from my perspective, if he believes he is only communicating about the child, then what's the harm in having an order indicating that they continue to use our family wizard and communicate only regarding the child?
Okay, thank you. Ms. Podolsky, what's the harm in that?
Your Honor, first of all, the issue of reconciliation has not been broached or brought up by my client since the beginning of this divorce. He is not trying to reconcile with his wife. He understands this matter is moving forward. As it relates to any matters of scripture, what he is sending does relate to the minor child. These are people of deep faith. It's very important to them. They continue to raise their minor child in her faith. And as we all know, raising the child in her religion and creed is a best interest factor. So what he may send to the other party is in fact relating to the minor child and continuing to raise her in the religion in which they were raising her together as a family. And so we do not believe that there is any issue regarding the communication. It continues to be solely about the child. It continues to solely be an Our Family Wizard. There's nothing threatening or harassing in any matter. So we're asking that the motion be denied today.
Okay. Well, it sounds like in this matter that obviously that maybe, and I'm not saying he did, but maybe the plaintiff, or excuse me, the defendant went beyond the bounds of, again, communication concerning the child. So the court will simply state that, again, the parties, when they communicate, would only communicate related to child-related matters. And then I guess we'll just have to see if that takes care of it. Mr. Todd, you can prepare an order which states that, again, that the parties would only communicate concerning child-related matters.
So thank you, Your Honor.
Okay, thank you. Court will end this matter at 10:41 a.m. You're free to go. Have a good day.
Thank you.
Court will note the appearance of Ms. Gillum on behalf of the plaintiff and Ms. Capture on behalf of the defendant. This matter is before the court on two motions: the plaintiff's motion for co-parenting communication rules and plaintiff's motion to show cause. Ms. Gillum.
Yes, Your Honor. Which motion would you like me to start with first?
It's up to you.
Okay. Okay, so we'll start with our show cause motion. So we have a couple of instances of violations of the current court orders, which one of which was entered in 2016, December 13th, and the other one was March 6th, 2023. One of the incidents was that the plaintiff's parenting time was taken by defendant from July 7th through 9th when he took it for his summer vacation parenting time. We have the issue of the agreed upon extracurricular activities. Their child has been in swim and has gone to summer camp, and for some reason these last couple of sessions and this last summer, he refused to pay her his share, which is approximately $245.50. We have the issue of August 26th when he left early to go back to Chicago because he was leaving the next day for training and left their son overnight with stepmother, which is in contradiction of the order. Also, there's the issue of the sober-link testing.
Does it say that he cannot leave the child with the stepmother?
So it specifically says, the wording says, Judge, that it says that if he's unable to exercise his alternate weekend parenting time or his other parenting time, that the parenting time will instead be during the day, so from 9 a.m. to 6 p.m. instead of an overnight is what it indicates.
Okay, go ahead.
Okay, and then the missed sober-link testing during his parenting time, there are about 28 missed tests from what we could discern by going through the calendar and figuring out what his parenting time was. And I mean, obviously this is a super big issue. The order was just entered in March. So just to not test whenever you feel like it, obviously is a concern. We're asking, obviously, the court hold him in contempt, make him pay the extracurricular expenses to award mom the makeup missed parenting time days. We're asking for a fine for the SoberLink testing, and also we're asking for attorney's fees for having to file this motion.
Okay, thank you. Miss Capture.
Thank you, Your Honor. First, I'm going to start with SoberLink. We have attached all of the SoberLink tests. We addressed the dates. The statement that it started occurring in March is incorrect. Defendant's been testing for SoberLink for 3 years. He's had over 1,500 tests. He's never had a failed test. He has explained to plaintiff on numerous occasions that there are occasions when the SoberLink is not working. Also, if you look in the SoberLink calendars, we've enumerated times when he did not have parenting time that he had labeled on the dates. A lot of these dates are simply times he didn't have parenting time, or that he had communicated with plaintiff that SoberLink was needing to be recalibrated. That happened on 2 or 3 separate occasions throughout March and April. So that's simply just not true. With regard to the parenting time, the makeup parenting time, or the missed parenting time, Mr. Marsh communicated with plaintiff stating that he wanted to exercise his 1 week allotted vacation time during the summer. The parties agreed. She did not object to it, and they exercised their parenting time. They also switched some dates. So around plaintiff ended up receiving an additional night on July 2nd, and didn't appear at the July 8th exchange. So obviously there was a miscommunication there, that plaintiff just willingly gave up her night. With regard to the extracurriculars, those are supposed to be agreed upon. Plaintiff has not communicated on any of the extracurriculars whatsoever with to defendant. Defendant has requested receipts, verification that the child is attending these swimming classes or summer camps. Plaintiff refuses to provide those. She simply just asks for a certain amount of money. And again, defendant and plaintiff never had a communication about any extracurriculars. Again, with regard to the August 26th, we have provided evidence that defendant did not leave until August 27th when his parenting time ended. I believe stepmom did bring the minor child to the exchange location. However, as evidenced by the itinerary that was attached, defendant did not leave the minor child during his parenting time during that period. So, Your Honor, we're asking for this motion to be denied in its entirety. All of the allegations that plaintiff has created here are false or exaggerated. And we're asking for attorney's fees for having to answer and come before the court on this.
Okay. Well, it sounds like we have a dispute, and maybe we need to have a brief hearing to address those particular items. So rather than go into the other motion as well, what we'll do is, are the parties utilizing Our Family Wizard at any app like that?
Yes, Your Honor.
So we would have we'd have documents concerning those particular communications as well. Why don't we do this is we'll contact you, we'll schedule it for an evidentiary hearing, and then we can present all of the evidence at that time, and the court can make an informed decision based upon the evidence. So that's what we'll do, and we'll conclude this matter at 10:49 a.m. You're free to go. Have a good day.
So I just want to be clear, Your Honor, that's for both motions. They'll be scheduled for the evidentiary hearing?
Yeah.
Okay.
We'll address everything at that time.
Okay. Thank you.
Okay. Thank you.
Please connect to audio.
Good morning to both of you. I will note we did have Mr. Magnuson involved in this. Has he appeared?
He is not in my waiting room, Judge.
Okay. This matter is before the court on the plaintiff's motion to set aside referee recommended order. Ma'am, in this matter, I do note that the motion states that, again, that you're trying to or you're going to affect a reconciliation and that you'll move in together, et cetera. Are you on public assistance at all on the children?
I'm just getting WIC as of now.
Okay, well, what happens, I can't drop the matter when there's public assistance involved. You can file, once you're back in together, you can file a motion seeking to modify at that particular point, but as long as there's public assistance, then there has to be support payable pursuant to the guidelines.
Okay, so
once you're back living together, that should effectively eliminate the public assistance as well. So you can go to them at that point, say, no, you're living together, and as a result, there's no need for that public assistance. And then at that point, then we would be able to cancel the order.
okay, so I basically just have to talk to my caseworker.
Talk to your caseworker and let them know, and then they can eliminate the I guess you say they could cancel the public assistance, and then we would be able to do something as it relates to the order.
Okay.
Okay.
So alrighty, so nothing can be done now.
Can't be done now as long as the public assistance is available, then the support as recommended would have to be paid.
Can I say one thing?
Sure.
Did you guys stop the order on my second job? Y'all pulling it from two jobs from both my jobs.
The same amount or what?
Yes, the same. Y'all pulling the same amount. Y'all pulling from JBS. Y'all pulling it from my second job too.
Okay. What I would tell you on that, sir, is contact your enforcement officer at the front of the court, and they should be able to get that taken care of. Now, what may happen, and I don't know if you have an arrearage or not, if you do have an arrearage, they may be collecting that to satisfy the payment of the arrearage. So that may be what they're doing. I don't know. So that's why I'm having you contact them and see if they could get the second order terminated in this manner. Okay. So contact whoever your enforcement officer is at the front of the court, and they should be able to resolve that issue if they can resolve it.
Which court does it have to be?
It's the front of the court. Just contact the front of the court's office, talk to the enforcement officer, explain that they're taking it out on both jobs, and they should be able to take care of that unless there's a reason for it, unless they're collecting for a support arrearage that isn't being collected on the first case. And I have no idea if that's happening or not.
All right.
Okay. Do that, and if necessary, you can always file another motion if you need. Okay. Thank you both. Have a good day, and court will end this matter at 10:56 a.m. Court will note that this matter is before the court on the defendant's motion to set aside referee recommended order in this matter. Mr. West, you can proceed.
Good morning.
Good morning.
So it was basically for the recommendation was to modify the support because of the effective date. The referee set it for September 28th. The original date of this support modification was originally August 28th. So I was objecting to the date. So I was basically asking the court if they can basically look into setting the original date back to August 28th. Under the circumstances, The plaintiff didn't show up, and that was because she didn't know of the date. And when I went and filed that paperwork, I sat down on that computer down there in the county clerks, and the original address was showing a previous address that plaintiff no longer resides at. I was told to put on there unknown, but I was under the impression, because under the notice to appear, it states on there that a notice will be sent to the plaintiff, Makiva West, pro per. So I thought she was going to be able to show up. So
Okay.
she didn't show up. She didn't get it. So I understand under the circumstances that it was adjourned, so she can show up. So I get that. I was also under the impression that was supposed to be a judge's approval for the signature. I just didn't see a judge's signature on there. I've seen the referee.
It's a referee order, so it doesn't need the judge's ruling or a order on that when the referee resets their hearings.
Okay. So I get them. I get that, and I support the adjourning so she could be there.
Okay.
But yeah, that's basically it.
Okay. Ms. West, do you have anything to say?
Yes, I'm not, can you guys hear me?
Yes.
Okay. I was not aware of it, but I did wanted to chime in on the address change. My address has been changed since I've been down here. We've had multiple Zoom meetings. That's the whole reason why we have Zoom meetings, because I no longer live in the States.
Okay.
So that's what's on there. I'm not exactly sure why I didn't receive a notice for the hearing, but I never did get one. I wasn't sure who.
Did you get the notice? Did you get the notice at the second hearing?
Yes, I got the notice for the second one on October 24th.
So they do have the correct address now.
Yeah, they've always had my correct address. That's why I was not understanding. I've gotten plenty of papers from there. I've received every paper except for that one that we had, I think, September 19th.
Okay.
And I wasn't sure why.
Okay. Well, I have no idea why either, but anything else that you have to say as it relates to the motion?
As far as the motion, the only thing that I had wished is it kind of set me back. I was under the impression that I was still getting my child support. It just stopped. I wasn't aware, kind of made aware of, hey, this will be your last payment. And so it kind of set me back. And so I was kind of trying to play catch up with it. Other than that, I mean, as far as going back, it's the only reason why I have no idea why I didn't get anything. I've gotten everything else from that.
Okay. Okay. Thank you. Mr. West, anything else?
Just one more thing there, sir. Is it possible to get some type of guidelines as far as child support regarding this case? Is that possible?
Oh, guideline. Yeah. You can go to, for instance, a service, you can go to michiganlegalhelp.org and go get in there. They have all the forms online, and you can get to the child support formula, and that will show you what the guidelines are.
Okay. You said Michigan Legal Help?
michiganlegalhelp.org.
Okay. Thank you, sir. I appreciate that.
Well, in this matter, based upon what you're saying, a court can't find that the referee made a legal error. The referee always has in these matters the discretion to set a date and when the support would be effective, and that's based upon a lot of facts. Based upon, like in this case, you had some issues concerning the adjournment, things of that nature, and that's again, that's not outside the bounds of what the referee can do. So the court doesn't find any error by the referee in making that determination, and the court just can't change. Well, it could, but the court doesn't just change the orders because unless the referee made a legal or factual error, which he didn't do in this particular matter. So the court will deny the motion at this time, and that will take care of this particular hearing. Court will end this matter at